G-325R, Alien Registration Form. Overview. My name is Sam Shihab with the law firm of Shihab, Burke. We are going to spend half an hour today with you to go over this topic. We're getting a lot of phone calls still. We thought maybe these things will die down, but more people are calling. And so we figure we spend 10 minutes to go over the alien registration application, little overview, kind of give it a different look or from a different angle, basically to give you a comfort with it and what the problems with it and what are the issues and whether or not you need to register. As we discuss every week, we have a website called immigrationquestions.us. You can post your questions during the week, and we will do the best we can to answer the good ones on every Monday and every Wednesday that we meet for half an hour. Without further delay, who is required to register? But before we talk about that, maybe we should touch a little bit of a history. The Alien Registration Act was passed in 1940, a long time ago. But the purpose of it was not to track immigrants for their immigration compliance, as this current law is doing. It was really for national security. It was after the Second World War. There was a security concern, or really during the Second World War, there was a security concern of foreigners being in the U.S. So they passed the registration law in 1940. And basically anybody who is foreign national in the United States for more than 30 days can stop at the nearest post office and register. Simple as that. Today, the same law, different face. The intent of the law today is to track immigrants and to go after undocumented, perhaps, and deport as many of them as possible. If you are a legal immigrant, you are also required to register, and many of you have registered, but not everybody has. So if you are a legal immigrant, who is required to register? Let's put that slide on right here for you and go over it. There is a website, the USCIS website has a very nice details about all the requirements and all the details, who's required and who's not required, but I kind of distilled it to a simpler presentation for you. Basically, legal immigrants and non-immigrants in the United States must register if they are here in the United States for more than 30 days and if they are on a visa waiver, on ESTA. Those who enter the United States without a visa, most European countries have an agreement with the United States or listed with the United States where their citizen can come in on a visa waiver. And many other countries as well outside Europe who have a low fraud percentage can enter the United States on no visa. These individuals, if they're here in the United States for more than 30 days, they must register. The second group are Canadians. Canadians who enter the United States on a no visa, they also must register if they're here within the United States. The third group, which we get most of the questions on, are those who are children who are turned 14 years old, either non-immigrants or green card holders, must re-register. That's another requirement. And a lot of people say, well, hey, I'm turning 14, but I have a green card, I can file an I-90. Do I need to register? It's redundant. Right now, the law as it's written, you must register. Another group is anybody else who believe that they were not fingerprinted and here in the United States in a legal status. You can register, and the USCIS told us that if you apply and we believe that you do not need to register based on our evaluation, we will let you know and we will not register you. So if you're in doubt, you can do it, but as I go through this presentation, you will decide whether you want to do that or you want to confirm for sure that you are required to do it first. And obviously, the biggest group that must register are those who are in the United States illegally, who entered without inspection and are not in deportation. And these are the group of people who must register based on the current requirements. Now, The question that a lot of people ask is how to and what are the steps. So let me go in and show you the steps required to register very quickly. You can create your myuscis.gov account. You can fill out and submit the form. USCIS will review and let you know whether you've registered or you do not need to register. And then you will have to attend a biometrics appointment for those that need to register. The steps are quite straightforward and they are not complicated if you've decided that you need to register. Things that you must be very much aware of, that if you're required to register and you do not register, there is a penalty of non-compliance. That includes a fine. It also includes imprisonment of up to 6 months. So this is serious business. You must make sure that you either are registered and therefore you do not need to re-register, or you go ahead and file a registration to be in compliance. There's a second requirement for those who are 18 years of age. They must carry a registration card with them that they will receive after they complete the registration process. The third requirement also that was mentioned in the law, in this registration law, that the requirement to update your registration and inform USCIS through your AR-11 of your relocation to a new address if you move, and you have to do that within 10 days. Failure to do that also subject you to penalties. Now, that's the registration in a nutshell. But there are some problems, and that's why I don't think we've heard the end of the registration laws, and I think there is more to come in the foreseeable future. First of all, the law does not specify if you are in the group of people who have registered by virtue of the fact that you have a valid I-94, or you have filed an adjustment of status, or you got a visa stamp on your passport and therefore you're considered registered. There is no instructions, clear instructions on what documentation you must carry with you to prove your registration. And since the law carries criminal penalties and a requirement for anybody above the age of 18 to carry a registration card, there's really no clarity on what you need to present with you, to have with you, to show that you are registered. And therefore that carries a problem in terms of clarity, because the law carries criminal penalties. It has to have more clarity. I would assume an I-94, I would assume an EAD card or a permanent residency card probably more than meets the requirements to show that you are registered, but the law is not clear on that requirement, and that's something that is a weakness that needs to be addressed, because confusion can happen, especially now that other agencies outside USCIS are enforcing immigration law, and they may not know that you do not need to have a registration card with you because you are pre-registered already. The other problem is the language barrier and the access barrier. The form right now is in English only and is online only. So for people who are on ESTA, for example, who do not speak English, and not every Canadian speaks English, a lot of Canadians are French speaking. These individuals may not have the ability to access it in their language and may not be able to speak English. Now, there is an interpreter component to the form, but it's probably not enough because it carries criminal penalties. You have to do more to make sure that people who enter the United States from foreign countries who do not necessarily speak English are able to comply with the law without trouble. And that's a concern right now with the law. The other big problem, and I want to put that on the screen if I can, is the issue of the questions being asked. So there's currently a lawsuit pending because the form lacks clarity on many things, and also it goes beyond the registration requirement. It asks questions that are more than the registration. The registration for me is, get your information so we know who you are, whether you're legal, you're not legal. We can reach you, your phone number, your address, some details, collect your biometrics, and that's it. But the form goes beyond that. Ask about your employment for the last 5 years. It asks questions that are very difficult to answer. Indeed they are. So, for example, that's one of the questions listed in the lawsuit that is not within the registration requirement. It goes beyond that, and it's a required question. And I should also note that the form does not include only required information, but also has a long list of questions that are not required that you can skip. And my advice to you that if you can skip a question, just skip it. You don't need to answer it. So there's a lot of questions you can skip. Just go ahead and skip them and answer the required question. But this is one of the required because it has an asterisk on it. And it asks you, what activities do you intend to engage in between now and your expected departure date? That's an open-ended question. For people on ESTA or people who come in on a visitor visa from Canada, for example, or anybody else who needs to register, who has a visa that requires to register, my advice to them is to answer the question in a broad way. I intend to do activities within my allowed visa, and I have no intention of doing any activities outside my allowed visa. So that's a question that I find it to be, not necessary and difficult to answer. It's difficult to answer what activities you're going to engage in between now and the time that you're departing the U.S. Here's a very big question, and I apologize. I am partially hiding the question, but I'll read with my picture. But I'll read all of it here so you can appreciate it. So, have you ever been arrested? And I want to repeat the word cited because the word cited also, have you ever been cited, ever been charged? Have you ever permitted or to participate in a diversion program? You have to understand what a diversion program is, including pre-trial diversion, deferred prosecution, deferred adjudication, or any withheld adjudication, or detained for any reason by any law enforcement official in any country, including but not limited to any U.S. immigration official or any official of the U.S. Armed Forces or U.S. Coast Guard, or, and this is the part that is covered, which is really critical, or by a similar official of a country other than the United States. If somebody's coming here on a visa, on a visitor visa to come in, or an ESTA to come in from Canada, from other countries, they don't have access to this information. It's just virtually impossible to answer this question correctly, given the circumstances and the complexity of the question. Also, not only is it complex, but it's also vague. Similar official of a country. Well, how do I know who is similar, who is not similar? My advice is if you can answer no in 100% comfort and strength, answer no. And if you have to answer yes, talk to an attorney before you answer yes. Now, for your 14-year-old son or daughter who must to re-register, most of the time the answer to the question is no, so that should not be a problem. So the next one here is the one also are extremely concerning, and it deals with, it's part of the lawsuit, have you ever committed a crime of any kind? And then it says, even if you were not arrested, even if you were not cited, even if you were not charged with or tried for that crime, or even if you were not convicted. That is a clear violation of the Fifth Amendment protection against self-incrimination. U.S. law does not allow, does not permit the government to force people to testify against themselves. And therefore, this law is unconstitutional. This question is unconstitutional because it asks you to try to admit that you have committed the crime that you were never even charged. Now, if you feel, and there's more of those questions, I just picked up 3 of them here because we're short on time. If you feel that any of those questions you will answer yes to, talk to an attorney before you answer that question. So I hope this overview give you a good appreciation of the G-325R form, the alien registration form that we have. I believe that this form will change with time and also perhaps will fade away sooner than later, I hope. So we'll see what the future will bring. All right, moving on to immigrationquestions.us. So I'm going to pick up a couple questions from immigrationquestions.us. I'm going to answer those, and then I'm going to go into questions that you guys have asked me, and I will do the best I can to answer them for you as well. All right, so looking for your questions here. Let me see if I can find them. All right, so let's jump into immigrationquestions.us. I am on H-1B. My son is on H-4. He is 16 years old. While he turned 14, we traveled to India. He attended an in-person H-4 visa interview. That time, his biometrics were taken in India. Does he again need to re-register in the new immigration registration to provide biometrics again? Does my wife, who is on H-4 and gave biometrics in the US 5 years back during H-4 extension in COVID time, need to re-register again or provide biometrics again? Well, to answer the question in both of them is that you do not need to register either one of them. You are able to skip the registration because your son is over 16 years of age, and therefore he should be in good shape. He's crossed 14. He's 16 now, and your wife is clearly in good shape. She does not need to re-register as well. All right, Paul. I just got married about to file an I-130 for a spousal visa. My wife don't have passport yet. Can she file without her passport information, or it is better to file once she gets her passport? If I don't file without a passport, will that hinder the process? So I would be interested to know a little bit more about her status. And why she does not have a passport. If her passport expired, I would include the expired passport and append it with the updated passport later. If she is on a valid visa in the United States and you can wait and the wait is short, it makes sense to wait to get that passport. So I would need to know a little bit more for Paul to be able to answer his questions in terms of what is needed in terms of waiting or going forward. I got a question from Hira. My marriage is more than 10 years now, and I have 10 years green card, and my spouse left the country and went back to his home country and got married there. And he will never come back again. Is my green card safe? Yes, your green card seems to be safe. I'm assuming if you got married again that you were divorced and you're free from him. But as far as your green card is safe and you should be fine based on the information you've given us. I have a question from Amit525. My wife and I became permanent residents in August 2022. We both had our biometrics prior to getting our green cards. Now, the question is, do we require to register with this new registration of Form G-325R? Are we part of the Alien Registration Executive Order? No, you do not have to register. You've already registered because you've done your biometrics when you get your application for a green card, and that's good news. All right, so now I'm trying to get into your questions. I cannot see them, to be honest with you guys, and they're not coming through. Let me see here. Here they are. All right, sounds good. So let's go ahead and take Runyan's question. Can someone who is an MTR for 485 denial due to USCIS error, if they want to try EB-5, can they just the status while waiting for, can they adjust their status while waiting for MTR in the country without going out? So you got a motion to reconsider, and unfortunately you got a denial, and you filed a motion to consider challenging it. It's a USCIS error, and you're in good shape. And the question is, can you file an EB-5 and file an adjustment of status without leaving the country? I'll be interested to know a lot more to answer that question. To be honest with you, it doesn't look like you can unless your last employment-based visa is less than 180 days from its expiration date. So let's assume you have an H-1B visa and it expired. You file your adjustment of status, you get a denial based on an error, you file a motion to reconsider, and under INA 245K you can file your adjustment. You can be in violation up to 180 days. So that needs, really, I need to look at that. So there's a narrow potential refiling, but I would be skeptical. So much more I need to know. To answer that question, Runyan. And I got a thumbs up from Alyssa Lego. She is our office manager and director of marketing in the office. Thanks, Alyssa. All right, so I get Kumar Amit. Should we carry passport and I-94 and I-787 all that time? That's a great question, and that's part of the, that's insanity if you have to carry your passport all the time and your I-94 and I-787 all the time. And that's part of the problem. The law does not tell you exactly what documents you have to comply with that, because otherwise you would be carrying, there's criminal consequences to not complying. Now, I would say an I-94 for sure, and an ID to identify you and identify that you have a valid I-94. Now, would I be shocked if somebody out there in some of the corners of this vast country who has the power of the police, a police officer of some sort who's commissioned to enforce immigration law, would not be satisfied with your I-94 only and demand that you carry your passport and arrest you because you didn't have your passport? Is that possibility exist out there? Yes. Likely, no. But would it be wonderful for us to know what it is that we need to carry to comply with this law? Because nobody wants to spend 6 months in jail. But that's an excellent question from Kumar. MD&T Strider, Active Kids Corner. I am on H-1B. My son is on H-4. He is 16 years old. Why he turned 14, we're traveled to India. I think we just answered that one on the immigrationquestions.us. So we'll move on to the next one. I think we've taken care of Mr. MDNT. And he was here by the name of Sharma. All right. I have a question from Tarun here. Dear sir, looking for your valuable suggestions. One of my friend's wife, H-4 visa holder, was charged with disorderly conduct in 2023 and got 6 months probation, which was over in 2024. Is it okay to apply for sealing the case and expungement records now, considering current immigration situation? Would there be any negative impact? Great question from Tarun. So under U.S. immigration law, an expungement of the record has no bearing on your obligation to provide this information, or her requirement to provide the information regarding the disorderly conduct when she's answering, for example, questions like the one we went through. She must disclose that question. She must disclose that question, the arrest or that conviction, the disorderly conduct conviction, and that probation that she went through. She cannot hide that, even if the case was expunged. Now, do I recommend that she expunge that record? I do, because there's many other situations, like in job applications in the future for her and so forth, that expunging the record is very helpful for her to remove that negative record in her public footprint. But with regards to any immigration case, she must provide all that details about that conviction, disorderly conduct conviction, and its details. I would make full record of that details before you expunge, because it's not very difficult, but it's difficult to obtain that record once it's expunged. And USCIS insists on having the full record for your information. All right. Can there be any negative impact on, if see no negative impact, and H4 visa extension, if the H4 is visa extension, I think we answered that question. All right. Nitin Kulkarni. I need to send my re-entry permit. I am not sure if I should look for the USCIS address based on my permanent address in Ohio or temporary address in North Carolina. Well, I don't know how long his temporary is. The address you're going to use is where the document is going to be mailed, and any USCIS request for evidence is going to be sent. If your temporary is 6 months, that's a long temporary. Permanent address is probably a better address. This question is from my son who studies in North Carolina, but we stay in Ohio. I see. So that's your temporary address for your son in North Carolina. Your son is going to be the applicant, not you, and you're asking me. You can definitely use your permanent address for your son, since his North Carolina address is temporary. That makes sense. Can I file an I-140? This guy's name is U.S. Immigrant. I like the name. Can I file an I-140 on J1 Clinical, considering it's giving only for 1 year by ECFMG? What happens when we go for extensions? There is an adoption and extension form about I-140 information. So I'm not sure you're referring to I-140 correctly. I think you're missing some piece of information, U.S. immigrant, to properly answer that question. I encourage you to go to immigrationquestions.us and go ahead and drop that in full details so you can organize it, because I think you're missing a piece of that question for me to be able to answer it for you. Thanks for answering. You're very welcome. Within 180 day waiting for MTR. Well, within 180 day waiting for MTR sounds positive, subject to really confirming, because this is an employment based. So I'll have to look at the fine print. So, well, that sounds, you check one of the boxes. We'll have to probably look a little bit closer to be able to answer your question correctly. All right. I mean, which USCIS PO box address should I use for North Carolina or for Ohio? I think you can use, again, Ohio, since Ohio is the permanent address for your son, and he's temporarily in North Carolina. That hits our 6:30 time. Thank you guys for listening, and Wednesday, we're going to come back and bring you one more topic. And you guys have a great